Hello, good morning everyone, and welcome to our Women in Sectional Title webinar today. I can't believe how time flies. It always seems as though we're doing a webinar, but it's great to have you with us. We're gearing up at the moment to attend the NAMA conference in Stellenbosch on the 12th of October, and I hope that some of you will pop past the stand that we've managed to secure. Our partners on this fabulous journey with us, we'd like to thank them again: ZFIN, CIA, PKF Octagon, BCM Track, Sectional Title Solutions, We Connect You, and Meeting PAL. We've got a lot to get through today, so I'd like to start by telling you that this topic, how to successfully lodge a CSOS application, has gained a lot of traction, and I think it's because people are interested and curious as to why applications are maybe being dismissed. We've had nearly 200 registrations for today, so I think it's really been amazing. I'd like to share the screen now with you. Let me just have a look here. Here we go. Right, and also I'd like to introduce to you and welcome I'm sure you know her very well. For me, we've worked together in the past, we've written a book together, and certainly apart from being colleagues, we are firm friends. So welcome, Karen Bleijs, lovely to have you here today.
Thank you, Marina, thanks for the invite, I appreciate it.
Great pleasure. Right, we're talking how to successfully lodge an application to the Ombud, and it's often easier said than done. Let's have a look firstly what legislation governs the CSOS applications. We know it's the Community Schemes Ombud Service Act and related practice directives. What Karen and I are going to do is, as I go through this presentation, we're going to maybe debate a couple of issues. There's a lot of information here, but we'll send you the presentation and take it from there. But there's certain things I want to highlight. And obviously, if you've got questions, please put them down and we'll reply to them at a later stage. So who can make an application? Any person who is a party or materially affected by the dispute. And that is really interesting because, as we know, Karen, that includes now, for example, a tenant. Is that right?
That's correct. A tenant, an occupant, which would usually be a tenant. And that's in terms of, well, if you have a look at Section 1, which obviously is your interpretation clause, and then Section 38 of the Act. The one thing that is very important to remember is that a developer is excluded. So a developer can't bring an application, and you can't have an application against a developer. And a developer is excluded in terms of Section 1 of the Act.
That's great news, because very often we ask that question. So thank you. Yes. That's a little gem that we can include. So what do you include in the application? The relief you're seeking and the grounds on which you are seeking relief. The names and addresses of all persons and the applicant considers to be materially affected by the dispute. But again, it's as easier as if you're an attorney, it's all very well and good to understand the grounds of relief that you're seeking, to gain remedies. But it's very difficult if you're a lay person.
It is. And that's why, carry on, sorry.
So the thing is, the grounds of relief, you can only seek relief from CSOS for a ground which is listed in Section 39 of the Act, and that's what we're going to go through. But there are certain grounds of relief where Section 39(7)(b) makes provision for those that are not listed in Section 39. So Karen, I want to put a pin in that. I'm going to talk to you about this afterwards, but let's just dive right into Section 39, which divides the grounds of relief into 7 categories. Correct. So you can go through financial, behavioural, scheme governance, meetings, management services, works pertaining to private and common areas, general and other issues. So let's have a look at the first one. Perfect. Financial issues, and I don't know about now, when I was on the Community Scheme Ombud Service Board, this always came up as most brought CSOS applications. Is that still the case?
It's still the case, although strangely in the Western Cape and in KwaZulu-Natal, there are not as many applications for arrear levies, which is extremely difficult to understand. But as everybody, especially the attorneys out there, will know, that there have been a number of court cases in the Western Cape where the judges have said you must first approach the CSOS before going to court or risk an adverse costs order. So if you're going to issue summons, then it would be best, in fact, to come to the CSOS. It is so easy and so quick these days to get an order.
Okay, great. So financial issues, let's talk about the financial issues.
Yes.
Taking out insurance. So, but to say, listen, my body corporate doesn't have insurance. I mean, that used to be gross negligence, or to increase it.
Yes.
To recover an amount from an insurance policy, to rectify payment method of contribution. This one is important. To audit financial statements of the scheme. So if I want an audit done, because I think everybody's stealing money, I can go to the CSOS to get an order for them to do an audit.
Definitely. If an audit hasn't been done for, let's say, 2 or 3 years, and an audit must be done, as you know, on an annual basis, then you can approach the CSOS. We will give you an order.
Okay, pay contribution or any other amounts, that would probably be for exclusive use areas. Then
Correct.
This one we were chatting about earlier, Karen, for the tenant to pay the scheme all or part of his rental in terms of the lease agreement. So in other words, if an owner is in arrears, then you can go to the tenant. So instead of the tenant paying his landlord, he pays the Community Scheme Ombud Service. But you were telling me something interesting here, which I think everyone needs to know, another gem.
If you are wanting an order against the tenant, and it is such a fantastic order, but it's often overlooked. But if you are going to ask for the tenant to pay, then you must cite the tenant. You must actually cite him as a co-respondent. You must give his name. And it would be preferable if you know what amount of rent he's paying, because then you'll know what will be deducted every month from the amount that the owner is owing. So please make sure that you name the tenant as a co-respondent, because there is case law, and in fact it is a sectional title case law. Marina, you'll know the building, Caroline Court in Killarney, where the judge in fact said that you cannot make an order against an unknown third party who may or may not in fact exist. So name that tenant as a co-respondent.
Would you have to have the original lease agreement?
No.
Good. No. Okay, because the courts used to want that for garnishee orders. So I'm happy to hear that.
Yeah.
All right, then we go on to behavioural issues. And oh my goodness, I don't know about you, Karen, but things are really going a bit pear-shaped with people's behaviour at this point. I'm just finding more and more, I think, stranger and stranger issues coming to the fore in my own practice. I don't know how it's going there at the CSOS, but I can just imagine.
Yes.
Okay, so what can you go to CSOS to do? To require a person to act or refrain from acting in a certain way which causes a nuisance. So that's a common law thing. If it causes a nuisance, you can go to the CSOS. But again, isn't it? It's evidence. You need evidence here. It can't just be my word against your word. That's
correct. So as in practice, as you will know, Marina, and everybody out there will know, if somebody is, for example, smoking dagga, and it's causing a problem, even if it's in the unit next to you and the smoke is billowing out of the window, collect evidence. Get your neighbors to give you statements as it happens. Film it if you have to. If you are having problems with your lungs, etc., get the doctor to give you a note, etc., etc. If I may just, you'll see the second one on the screen says removal of an animal. You cannot, as the owner of the animal, bring the application against the body corporate saying, I want to keep my animal. The body corporate can only bring an application against you, because you'll note that it does not say there for you to, or it doesn't word it, I want to keep my animal. So you can't say, please give me an order that says I may keep my dog. Only the body corporate can bring that application.
Yeah, that's interesting. Absolutely. Okay. And then we go down to removal of animal being kept in scheme but contrary to conduct rules. that the body corporate will bring.
Correct.
And removal of articles placed illegally or attached to private or common areas.
Yes.
Just one thing I want to raise here. If the body corporate is bringing a matter to CSOS,
Yeah.
we had a case the other day where the trustees didn't resolve, they didn't put a written resolution together on this. And only afterwards they said, oh, sorry, we forgot about that. We'll do it now. Once it had gone to the CSOS, but the CSOS doesn't allow the retrospective signing of a resolution, as I understand it.
You know, only in certain circumstances, but not in this particular circumstance, because you can't, when the CSOS points it out to you or to the body corporate, they can't say, oh, golly, we forgot.
Yeah.
Because let's give you an example of an order. Yes, we can't point it out to you. So I did an order perhaps 2 years ago where the respondent had placed a pizza oven on an exclusive use area.
Mm-hmm.
And in terms of the Sectional Title Schemes Management Act, in terms of the management rules, you need a resolution from the body corporate, not a special resolution, ordinary resolution, to place something on the common property, on an exclusive use area.
Yeah.
And they had the pizza oven there for 2.5 years. So that was quite a long time to have it there, and many people didn't know about it, so it wasn't causing a nuisance to anybody. At that stage, you can't, there's a historical fact that it's been there and it hasn't worried anybody, and now suddenly the trustees decide to bring the application. So have that resolution in place beforehand to say, well, you must remove it, and these are the reasons.
Yeah, absolutely.
For example, so that's why your application must be in order.
Yeah.
Resolutions must be in order.
All right, next category that you can go to the Ombud to seek relief is for scheme governance issues, requiring the scheme to approve and record new scheme governance provisions. So if you wanting to get your certificate in a sectional title scheme, your compliance certificate, declaring a provision invalid and requiring a scheme to approve and record a new provision to remove the invalid provision. I'm dealing with a lot of these lately where the rules are not carved in stone. So at the end of the day, if something is unreasonable or contrary to public policy, you can go to the CSOS. Do you feel people are utilizing this enough, Karen?
No, we get very few applications with regard to this.
Is that so? Okay, that's really interesting, because if something is unreasonable, it should be removed, and I think there are grounds to do that. Yes. Also, just a quick question I wanted to ask you. You are a permanent adjudicator at CSOS at the moment. Are all adjudicators qualified attorneys?
Without a doubt, they are. They're either attorneys or advocates. And we have a number of very senior advocates who are adjudicators.
And do you guys speak to each other? I know you mentioned you've got certain groups for the permanent adjudicators, just so that everybody's speaking from the same song sheet kind of thing.
Yes, we have a forum, if not every week, every second week, where all the adjudicators meet and we discuss case law, any niggling points that need to be sorted out. And all of our ombuds, as you know, are either attorneys or advocates, and one of them is in fact a previously practicing magistrate. So we sit and hammer all these matters out. Any problems, we hammer them out.
I think it's important for all of us to know that. It's great to know that you're discussing things behind the scenes. Okay, category now that you can also take on meetings. A lot of meetings, people want to invalidate meetings. I get calls a lot where people will say to me, listen, we had a meeting last night and everything was wrong, so we're going to the CSOS. So requiring the scheme to call a general meeting of members. If the scheme is just sort of recalcitrant, doesn't want to call an AGM, you can go to CSOS to get an order. Declaring the purported meeting of executive committee or was not validly convened. I would assume that's the trustees. Declaring that resolution purportedly passed at meeting is void, and motions are not passed because they're unreasonable, and declaring that a resolution passed at a meeting is void because it unreasonably interferes with rights of owner, occupier, or rights of a group. So this is the time that you can go under this meetings heading for the resolution side of things. Okay,
yes.
Good. Right, meetings, management services, also. Bane of my life here, requiring a managing agent to comply with terms of contract of employment and any applicable code of conduct or authorization of the scheme. So this is where people don't know if you can take your managing agent on. You don't have to go to court to do that.
Yes.
Or we can get an order declaring that the scheme does or does not have right to terminate contract of appointment with managing agent.
We do a lot of those.
Okay. What about a managing agent who really digs his heels in or her heels in and says, look, I'm not parting with the documentation. They're often causing severe prejudice to the new managing agent. Is that dealt with on an urgent basis at CSOS?
We'll do it on an urgent basis if a real urgency can be shown. For example, if they won't hand over the funds of the body corporate for a valid reason. So that is one of the reasons that we'll do it on an urgent basis or a semi-urgent basis.
Okay. In works pertaining to private and common areas, if you need your scheme to do repairs and maintenance, and I must say, every time I start going through the CSOS awards, just for interest sake, see what's going on, there are a lot of these. There are a lot of these because buildings really are just not maintaining and repairing. And I think that's a huge problem and maybe an area where the CSOS could get more involved. Requiring a specific person to carry out specific repairs or to pay a fixed amount to the applicant as reimbursement for repairs he or she has carried out. Very useful. Requiring the scheme to carry out works on common areas for convenience or use or safety of owners. Declaring decision of scheme not to make improvements on common areas unreasonable. So somebody says, well, look, we're not doing this necessary improvement. We don't think it's fair. We don't want to do it. You can go to the CSOS to get that overridden. Yes. Requiring a scheme to acquire, not to acquire or dispose of specified property for owners or occupiers within the specified time period. I've never really seen that.
I've never seen that, no.
Doubt it. Declaring that the scheme has unreasonably refused to grant owner exclusive use rights over certain parts of common property. Yeah, also that you see, there's so many. It's like you've got a bit of an arsenal of weapons in this, and people haven't really fleshed out Section 39, so they're not sure where they can go with it.
Yes, I must tell you that frequently we'll get an application, and because we're a public body and really we are there to help consumers, we will look at the application and say, where can we fit this in? Because ultimately we don't want to dismiss it. Yes. So your case management officer who'll get that's the first line of defense, if you like, who'll get the application will often phone the adjudicator and say, where can we fit this in? We don't want to turn it away. And then we'll try to assist because they don't want to. We don't want them to have to go to an attorney and spend extra money, and we'll try to fit it in here.
Okay.
Yeah,
that's good. That's great to know. Okay. In general and other issues, declaring that an applicant has been wrongfully denied access to information or documents. I must say, owners love this one. They love it to be able to go to the CSOS and get that order to force the body corporate to hand over documents. Yes. And again, I always don't understand why they withhold documents. At the end of the day, it's putting you on the back foot as the body corporate trustees if you're not going to hand documents over.
Yeah, I agree with you.
This one here, Karen, this is what I want to understand. Any other order proposed by the Chief Ombud? Have there been other orders proposed by the Chief Ombud?
All right, now that is, if you like, as they say in law, it's a numerus clausus. You can't come and say, well, Ombud, try and fit that in, because the Ombud's not going to look at it and decide. It's already the Chief Ombuds. There've only been 2 so far, or 3, one we won't speak about, but has already laid down what those orders are in terms of the what do you call it, the practice directives.
Directives, yes.
So the practice directive of 2018, I think it's the first practice directive, sets out what can be included, and it's a question of urgency. So there are 3 grounds of urgency, and I've actually written them down so that I don't forget. The first one is that there's an immediate and serious health risk. The second one is a deprivation of services like electricity, what's called in law spoliation, cutting off electricity, etc., cutting off water, gas, and then there's one more. So anything that you could, so the last one, I did one 2 months ago where the lady had applied timeously to slaughter a goat for cultural reasons, and the body corporate came back to her and said, sorry, it's not in our rules, but as we both know, it's a constitutional right, as we all know, it's a constitutional right to do so. And they had simply said no, but it was a reasonable request. It should have been in the rules that she should be permitted to do so. And
subject to provisions, obviously.
Correct, subject to provisions, and she was prepared to comply with all those provisions. So she was granted that on an urgent basis, and the urgency was within 2 weeks, subject to complying with all of those provisions. Yeah, so urgency really, and of course another one where there was a major sewage spill occasioned by the body corporate, and they did not want to clear it up. So they were ordered to do that within a specific time. It was a major sewage spill. And then disconnecting electricity. And then you sent me a question and said, please consider this. And that is loading levies, arrear levies, or anything else onto a prepaid electricity meter. It's definitely a no-no, it's illegal. So if that's done, we will grant an urgent order against the body corporate or the managing agent. There's a particular managing agent in Johannesburg who, unfortunately, notwithstanding numerous orders against both themselves and the body corporate, they continue to advise the body corporate to disconnect electricity or load the prepaid meters. And it's clearly, and there's case law, and if anybody would like that case law, they can ask you, and I'll forward that case law to you. That to meddle with an electricity supply meter in any way is unlawful.
Thank you. Thanks for clarifying that. That's great to know. Thank you.
Yeah.
All right. We've got time limits on certain applications. Yes. And if you want to make an application for an adjudicator to declare a decision made by the scheme or the trustees void, you actually have to do it within 60 days of the decision being taken. Yes. And I think that's reasonable, and I don't see anything wrong with that, although an ombud may condone this late submission of the, of this nature, provided that good cause is shown. I suppose what would good cause be?
Good cause would be
legal.
The usual thing that you would in any court application, but let me give you an example. The interests of justice, again, I wrote it down, the length of the delay, the explanation of the cause of the delay, the prejudice and the prospects of success. Can I give you a very quick example?
Yes.
You have a meeting to pass, I think it's it's a unanimous resolution to change the use of common property. So you have a beautiful garden and you have a special general meeting where you're going to change that garden to have 5 parking bays. And my kitchen overlooks the beautiful garden that's going to be suddenly ripped up and put down 5 parking bays. I'm not going to have the enjoyment of any of those 5 parking bays. You have the meeting on a particular night, you don't have a quorum. The next day, I go overseas for 2 months. I come back and I realize that what the managing agent, who unfortunately doesn't have much experience, has done is they have merely postponed that meeting for a week hence, as you would at normal general meeting where you're going to pass an ordinary resolution. Now you can't do that, because if you're going to need a unanimous resolution, you need to have an 80% quorum. So you can't just postpone it for 7 days. So I wait another month and I bring the application. They haven't started digging yet, and they haven't started removing the garden. So I must bring an application, a condemnation application, to the Ombud, the Chief Ombud, and I lay down all my grounds: the length of delay, I was away, explanation, I was away, etc., etc. Nobody is really going to be prejudiced because the garden's still there, the body corporate hasn't spent the money, etc. And I have a firm legal basis that I have a right, my constitutional rights, my proprietary right is being affected, etc. And the Ombud would be reasonable for him to accept that application. If I brought the application 3 years later and it was a fait accompli, that it was then the Ombud would be right in saying, no, sorry, you've brought it too late.
Yeah, absolutely. I'm going to go through very briefly the process of this application. You've got to complete in full and submit an application form. I've got this form in front of me, and it's all those block letters, which I must say, I always write all outside the blocks. I never write in the blocks.
You're not the only one.
Details of application. And, you know, it always gives this little block of space. So it's like that you've got to write everything in. I would think that a good piece of advice would be for people to actually separately write their application, the relief they seek, the facts, and all of that. Because people, I've noticed, have tried to squash their whole story into a very small space. Also talks about what has been done to try and resolve this application. We know that internally, you've got to internally mediate. Is that correct?
Yes, you must. If you have something like that, say refer to Annexure A, refer to Annexure B, you must try to resolve internally. As you know, Marina, in terms of Management Rule 17.1, I think it is, it could be something, one of the other subsections, you have the right to call a special general meeting by obtaining the support of members holding 25% of the participation quota. That's one of the internal dispute resolution mechanisms.
Oh, interesting. So that's 17.4. Yes, absolutely.
17.4, correct.
People don't use it. They don't use it enough. They really should.
Yes, they must.
Okay. All right. Then we can't just say the fee. We know that the fees have now were waived. The fee for mediation and an adjudication, those have all been waived, which is really fantastic.
That's right.
Process of application. Ombud must also publish and make available the copy of the order. You can also apply for further information. The Ombud often, I think you often ask people for other information. This is what I'm interested in. Grounds for rejection of applications. Relief sought doesn't fall within the jurisdiction of the Act that we've spoken about. It's not in terms of Section 39. It doesn't comply with time limits. It doesn't transmit written confirmation to the Ombud within 14 days after receiving notice to proceed. So you're not internally dealing with the Ombud properly. This one I want to understand a bit better. Ombud is of the view that dispute must be dealt with in court of law or other tribunal. It's always like the other way around now. I suppose I did have one case here, Karen, was about the body corporate wanted to declare somebody sort of mentally unstable and place them under administration and took it to the Ombud. So I suppose that's where the Ombud says, no, you must take that to the High Court. That's correct.
It falls within the exclusive jurisdiction of the court, but there's something else which is very important, and that is that if the matter is already in court, so if the body corporate has already issued summons, they cannot bring it to court, because it's what's known in law to the Ombud. It's what's known in law as lis pendens, as you know. So it's pending in court, And if you want to bring it to the Ombud, then you must first remove it from the court. So you must withdraw it. The other thing is that if it's raised judicata, in other words, it's already been decided in court. And that's more for the layman to know that if a court has made a decision, you cannot bring it to the Ombud because the decision has been made in another forum. That's very important.
We carry on, and if the application is not rejected, the Ombud will serve a notice on the scheme and to each person materially affected by the application, or each owner individually. So basically what they need to know is that they need to ensure that the notice comes to the attention of everybody. Documents, details of parties, relief sought. So there's no ambushing in this kind of process.
Never.
Adjudication fees we've spoken about. And now this here, legal representation, they're trying to sideline us attorneys. But at the end of the day, there's nothing stopping attorneys from assisting people to put together their applications. And I think that's important. You sometimes need expert advice to put together the application, but certainly not to go to the hearing unless it's a very complicated issue or all the parties and the adjudicator consent to that. I don't think there's a high percentage of attorneys attending.
There's not a high percentage, but certainly, as we know, all of us here know that the Constitution states that you're entitled to legal representation. However, what we find sometimes is that some attorneys will step in and try to milk their clients. I had a recent case where, in terms of Section 39(7)(a), the applicants, which were one or two members of a body corporate, were saying, we are being denied access to documentation in terms of the Sectional Title Schemes Management Act. And the attorney was alleging that this was such an intricate matter that he had to represent his client. And so he wrote a huge tome and said, they have to be legally represented. And so I considered, I said, really, your clients don't have to be legally represented, because it's simply a matter of saying what they've been denied access to. And you know, you don't have to apply, you don't have to appear in person, and you don't have to be. Simply tell me what they've been denied access to, and then the other side must say why.
Correct, absolutely.
But it can be a very intricate matter. And then as an adjudicator, I will certainly never deny, and I don't think there's any other adjudicator that would deny legal representation under those circumstances.
All right, we want to go through this just quickly. The Ombud must notify the applicant of any submissions received, allows inspections. You can make, anybody can see all the documents. That's basically what this slide is saying. And the applicant can also amend his application, and the Ombud has the discretion to approve or deny that request. An application can only be withdrawn or amended before the Ombud refers the application to an adjudicator.
Yes.
And once it's gone to an adjudicator, then it can't be withdrawn.
Correct.
Okay. All right. So we said that if there's a conciliation first, the Ombud, if they can't mediate, and I know that there are a lot of successful mediations at the Ombud. When I was there, it was heartening to see how many matters were solved by people talking to each other. But if you don't get that, then you obviously got to go for an adjudication. You can go straight for adjudication if the Ombud is of the opinion that there's a reasonable prospect of settling the dispute. So if you say, look, these people are not rational, they're never going to mediate anything, then you can go straight to adjudication. Now this one, when you choose your adjudicator, if you're paying for it, or if you used to be paying for it, then you can choose the adjudicator. If you were getting discounts or waivers, then the Ombud used to choose the adjudicator. But now, because there's no fee to pay, it looks to me like the applicant and the affected parties together choose the adjudicator. Are they furnishing parties with adjudication lists?
if the parties specifically request, but generally they leave it to the adjudicator because, yes, it's allowed, but we have found that people can get very, very difficult when it comes to the appointment of an adjudicator. We've had instances where they go hugely deeply into the background of the adjudicator, and but if an applicant specifically requests that they'd like to choose the adjudicator and agree on the adjudicator, it's infrequent that they'll agree, because then they will see that they'll see some sort of sinister motivation. Yes, why the other party wants that adjudicator and they won't agree. So, yeah. So
yeah, absolutely. Okay. The functions of the adjudicator: to investigate the application, to decide what's appropriate, and obviously must look at the law and the civil courts and that type of thing. We know the powers of the adjudicator: you can ask for documents. Do you ever go and inspect areas in question? I know that's something that they raised at the very beginning. If an adjudicator is not certain of the lay of the land, they can go and do on-site inspections.
We actually have a number of investigators that are authorized to go on our behalves.
Yes.
Sorry.
Yes.
So, and these are also qualified people who can investigate. They're qualified. Yeah. I know one of them is a forensic investigator, qualified forensic investigator. So they are qualified. I have never gone out myself, because generally photos will suffice.
Yes, absolutely. Are you still doing hearings virtually, Karen, at the Ombud?
Either virtually or on paper, because we have found that it is. But if somebody specifically asks for a viva voce or a face-to-face party, we will face-to-face hearing. We'll do it.
All right. So adjudication orders: grounds for dismissal. The application is frivolous, vexatious, misconceived, or without substance. I had a client yesterday who said that her application was misconceived, but I can absolutely understand why. I won't even go into detail about that. The applicant fails to comply with requests made by the adjudicator, and then the costs. Talk us through costs very quickly.
So, if the parties are legally represented, we can grant costs as any magistrates can. Costs on a party and party, attorney and client scale. And if one of the parties is legally represented and the other is not, then we'll err on the side of caution and not grant costs, and say right from the start, we are not granting costs, because, the CSOS is for the layman. So we don't grant costs. If the layman is involved, we don't grant costs. That's why the CSOS is there. If the application is misconceived or frivolous in the extreme, then we will grant a maximum costs, as this says, amount cannot be more than the maximum amount prescribed. We grant costs against the applicant, not against the respondent. So the applicant cannot come and say, look, I want costs against the respondent. We're not allowed to. We will grant costs against the applicant for 5,000 rands. That's the maximum.
Okay. There's a little bit more here about the cost order that people can read. But yeah, I think it says here as well, possible orders that one may come across require the person to act or refrain from acting in a particular way, contain ancillary provisions that the adjudicator considers necessary or appropriate.
Okay.
And,
I'll give you a quick explanation of that. That's going a slightly further. So Section 39 says you can do X, Y, and Z.
Yes.
But if I'm asked to grant an order to that so-and-so must switch on the lights, it's an urgent order. So switch on the lights, or at least see that the lights are switched on. To something that is ancillary to that order would be, for example, do not disconnect or terminate the electricity supply to the unit again unless you are in possession of a court order to that effect.
Oh, I see. Okay.
It's more effective than saying don't terminate it again.
Yes, I understand. Also, there's one thing that often pops up. People say to me, we wanted to get the trustees out. So we went to the Ombud for the Ombud to make an order to remove the trustees. I mean, obviously the Ombud can't do that.
Can't do that. It's not in Section 39. And that's why Section 39 is so critical, that people will read that and use it. So another thing that we often find is that somebody will utilize a portion of Section 39 and then give us 30 sub-orders under that. That's also not permitted. It's Section 39 is it.
Absolutely. Then distributing the order, the adjudicator's got to provide the order to the applicant, the scheme, the Ombud, and any other affected parties. And yeah, not individually, but people must understand and know about it. And then obviously the enforcement order, you can enforce the order. It's not automatically, the award is not automatically an order of court. The applicant would need to go to the court so that it can be made an order of court. I understand that's quite a quick and easy process. I'm not going to go through appeals. If anybody wants to understand appeals, you're very welcome to get this the slide. But what I would like to say, just a couple of things from my perspective, and then Karen, I'm going to give you an opportunity because we've got to end now. From my point of view, speak to the facts. I've got so many clients who want to put 30 reasons down and all the emotion and everything that goes into it. And then the poor adjudicator, I mean, look, think of Karen sitting there wading through all this irrelevant information. It'll just put her back up and you're not going to get the proper service that you want. Choose which battles to wage. Don't make things long and tedious. In a 2019 directive, we were told, use plain English. It's not necessary to use legalese as a lay person in an application. And what I said to you earlier, on the form, use a separate sheet so everything's not squashed up. It's just easier for the adjudicator. And use documents to support your argument. That's definitely from me. Karen, I don't know if you'd like to add something.
You know, as with any court case, you need evidence. Otherwise, you've got nothing.
Yeah.
One more thing about enforcement orders. As far as jurisdiction of the courts is concerned, when it comes to magistrate versus high court, you've got your enforcement. At least you've got your jurisdiction in terms of money. But when it comes to enforcement orders, any order that is saying that you must do this, you must do that, or you must refrain from doing that, that's always a high court order. So in the high court, you would go to the, so in the lower courts, you'd go to the clerk, and in the higher courts, you'd go to the, I can't remember it at the moment, what do you call that? The
magistrate.
So the magistrate's called the clerk, and the in the high courts,
registrar.
Thank you. Thank you. Yes, the registrar. And they're the ones that stamp the order. And when they stamp the order, it automatically becomes, the enforcement order, it automatically becomes a court order. And then it can be served by the sheriff. And that's when you pay, because you'll pay the sheriff to go and serve the order.
Okay. All right. I see that we've got a lot of questions and a lot of issues and problems. I think the way that I would like to deal with that is we copying all of these questions and maybe typing them out and sending them through to the Ombud, and then uploading them for all our members to see if we can help. And I think it's great to talk about these things because there's maybe advice that both the Community Scheme Ombud Service appreciates and what we also appreciate. So Karen, I don't know if you'd like to leave us with anything new or anything that that's hip and happening at the Ombud Service that we would like to know about?
There isn't really, but I would like to say that always go onto the Ombud Service website, because there are very good, helpful hints on the service. And you all know Jolene Wasserman. She's very proactive, and there are little tips from her on the service, and she's also extremely helpful. If I may say one more thing, Marina, thank you to you. Thank you to all the attorneys out there that are proactive in sectional title. So Linda, for example, and all of the others, for everything that you're doing And hopefully there'll be a lot more assistance from you and collaboration with the Ombud Service. So thank you very, very much for everything that you're doing.
Oh, thank you, Karen. That's really kind. I appreciate it, and I appreciate your time, and also that the Ombud has allowed you to come and talk to us today, and hopefully we can have many more interactions like this. For our next webinar in October, I'm thinking of bringing all the learnings and best practices that we hear about at the NAMA conference in Stellenbosch back to you, so we can be really at the forefront, at the cutting edge of what's going on in our sectional title industry. So to all of you, thank you for coming, thank you for joining, and we'll see you in October. Bye for now.
Bye-bye. Thank you.